Well, it appears the California Supreme Court is trying to address the issue of juvenile life sentencing, and they appear to have some thoughts on it. They just don't know what to do about it. My guest is retired Superior Court Judge from Santa Clara, California, Judge Eugene Hyman. So what are the justices trying to do here, Judge Hyman?
Well, they're trying to be compliant with the Supreme Court decision which came down relatively recently, which basically said that it's cruel and or unusual punishment to be sentenced for life for a non-homicide related case. There's plenty with gang cases and things like that where there's shootings and guns and those kinds of things where a person can wind up with a life sentence. And the Supreme Court, in a 5-4 decision, said that that's in today's standards. That's cruel and unusual punishment. Now, what's interesting about that is that there are people on the U.S. Supreme Court that are originalists that say that you interpret the Constitution based upon thoughts of 1787, I believe, which is when the Constitution was approved, rather than applying today's standards in terms of what's cruel and or unusual. So there's always that debate in terms of what's unreasonable. Of course, under those rules, the death penalty for kids as young as 14 was reasonable. But in any event, so the California Supreme Court is trying to say, well, gee, the U.S. Supreme Court said that a life sentence for something other than a homicide-related matter is cruel and unusual, but can we impose, or can there be imposed, a life sentence for attempted homicide? Is that within the meaning of the Supreme Court case or not? And there's some pretty strong feelings based upon how the media reported the oral arguments in terms of the courts wrestling with that decision.
And then talking about the Graham case in this particular instance here. So we're talking about there are some kids, I shouldn't say kids, but juveniles who are sentenced to, for example, 75 years. But that's
Right.
not considered a life sentence. But in reality, right. I mean, it essentially right. is. So
right.
there's what constitutes a life sentence, and there's really no delineation as to that.
Well, yes, because there's also, in terms of cruel and or unusual, various courts, including the U.S. Supreme Court and the California Supreme Court, have wrestled with what's an unreasonable sentence, and they've held that, let's say in serial molest cases, several hundred years of a sentence is not cruel and or unusual. So that issue has to be addressed in terms of, for a juvenile is a 75-year period for a a non-homicide case, whether that in and of itself is cruel and unusual. You're correct. Is that a life sentence for all intents and purposes? And then the second issue is, above and beyond that, is receiving basically a life sentence for an attempted homicide but not a completed one. Is that in and of itself cruel and or unusual? And given the arguments and how it's been reported, they really aren't giving too many clues in terms of how they're going to rule.
Now, sitting back there as a judge yourself, so you're looking at the Graham case, for example. He's
right.
someone who shot multiple people and they all survived,
right.
and they're saying, well,
right.
you know what? It's not the fact that they all survived. It's just the fact that, two, his intent, and two, he's probably a bad
right.
shot. So
right.
he intended to kill these people. Is intent
right.
enough in your mind?
Right. Well, the other way of looking at it is not to just look at the aggregate sentence, but he received consecutive sentences. So none of the individual sentences were cruel and or unusual because he didn't receive the equivalent of a life sentence for any one particular crime. He received it based upon the fact that it were multiple victims. So I think logically one way of looking at it, they can actually, I think, sidestep what is a life sentence based upon the fact that this was multiple victims and he received multiple consecutive sentences. So he didn't receive, in essence, a life sentence for one particular crime, but for a series of crimes. So I think ultimately, when this case comes down, I'm predicting that they're going to sidestep the issue based upon the fact, not even have to address whether you can receive, quote, a life sentence, quote, for an attempted homicide, but rather based upon the fact that it's multiple attempted homicides and he received a consecutive sentence for that they might be able to resolve it based upon those factors and not actually address the ultimate issues. Now, I think it would be helpful if they did address those other issues, but courts in general at the appellate level have a tendency to sidestep issues unless they're squarely presented.
Do you ever see in closing them just coming up with a number? If this is a juvenile, the maximum they can get is, say, 50 years. Is that something that you could see happening?
No, I think what they might do is say, what is a period of time that still allows a person the possibility of being paroled, because that's what we're really talking about when we say a life sentence. When we're talking about a non-life sentence, we're talking about there is the possibility, no matter how remote, that this person might be paroled prior to the end of their life. The other issue that I would like to see them address that they might not address has to do with child developmental issues and the fact that juveniles research, and there's absolutely no dispute, the juvenile brain is still developing until the early 20s, and as a result of that, there needs to be other considerations as well. But whether they will address that issue or not, I don't know.
I mean, I suppose, psychologically speaking, there are ways of determining whether someone is just a stupid juvenile or a sociopath.
Sure.
And I mean, that would seem to be a logical consideration.
I agree with you, but interestingly enough, when I was in juvenile court, I don't think in the 5 years I was there that I ever saw anyone that was diagnosed that way. And I think there's a reluctance on the part of professionals, whether they be psychologists or psychiatrists, to pigeonhole juveniles on a theory that their brains are still evolving. But I certainly saw people that I had some serious concerns about, whether they were seriously antisocial. But I think you have to leave open for the possibility that, maybe they may not be. I mean, at what point that we're now diagnosing juveniles with schizophrenia, with bipolar, and with other kinds of mental health illnesses. When I was first in juvenile, it wasn't done on a theory that you can't diagnose someone with those kinds of labels until they're in their mid to late 20s. So that theory is evolving as well. So ultimately what they do is going to be very interesting.
All right, Judge, thank you.
Thank you.